I'm Professor Schmidt, and as many of you know, I teach constitutional law here. And I thought that I would talk a little bit about how Justice Scalia has influenced constitutional law, what sort of legacy he has left. And in a sense, I think that's going to give us a good picture of how things could change as we move forward. And I think that's true because who is on the Supreme Court matters an awful lot. And I'll try to stop pacing, and that's what I normally do, and so I stay on the camera. All right, so I have a bad habit of pacing. But who is on the court matters an awful lot. You know, one of the things Justice Scalia stood for is that maybe it shouldn't. The law should be neutral. We should interpret the Constitution according to its original meaning in a very neutral way. But as a matter of history, legal history, it matters. I started my scholarship by writing about how the courts could have struck down or at least made some inroads into the aggressively pro-slavery law of the 1850s. And I think that's true. I think a more stark example is what we just covered in con law today. Brown versus Board of Education, when it was first brought to conference, was a 5-4 vote to uphold Plessy versus Ferguson. Justice Vincent dies, is replaced by Justice Warren, and then we have a 9-0 going out the other way. And so who is on the court matters an awful lot. It can lead to a different opinion, a different way of looking at things. And so Justice Scalia's passing, although it's very sad from a humanitarian perspective, just I feel bad whenever anyone passes away, of course, but it really, I think the importance is that it provides an opportunity for the court to change quite a bit. And since it's an election year, I think we're also going to be faced with something that is unique, or at least doesn't come around very often, and that is a chance for the country to really be involved from a political perspective in shaping the Constitution. We actually have a long history of that. It's called in the literature popular constitutionalism, of the people deciding what the Constitution should mean. And that's something that Justice Scalia, in a way, liked and stood for, is that it shouldn't be those 9 guys up on the Supreme Court, it should be the country. And so with the election, I think that these things that I'm about to list through are going to be hot topics in the election. And even though I agree with Professor Roeder that Obama has every right to appoint someone now, I think that the reality is they're unlikely to get confirmed anytime soon. And so these issues are going to be a big part of who a lot of people vote for, and it's going to be important in the election. And we're going to have, in a sense, an ability to decide what kind of Supreme Court we're going to have, what kind of Constitution we're going to have. So I thought I would just run through, at least with respect to the course I teach, what Justice Scalia has done to the doctrine. So in Constitutional Law 1, we talk an awful lot about the powers of Congress vis-a-vis the states, federalism. And Justice Scalia, I'm sure as all of you know, was a big champion of a limited federal government, which would empower, and by doing that, empowering the states. Probably the most well-known example of that would be the Sebelius case, where he disagreed with the court upholding the individual mandate. He disagreed from a Commerce Clause perspective. He disagreed from a Taxing Clause perspective. He thought we shouldn't be able to do it, right? And then he actually did carry the day with respect to the expansion of Medicare, right? So he's a big champion of a limited federal government. As other of the panelists have mentioned, he championed an expansive interpretation of the enumerated rights. So the Second Amendment, he was big in favor of that, and the way he interpreted it was that the states shouldn't be able to do much at all. I don't think that's inconsistent with his stance that I just mentioned, because that's actually in the Constitution, the Second Amendment, but he had a strong opinion on the federal government staying away from any regulation of firearms. Free speech. He's been a champion of free speech. That's, of course, is another right that is enumerated in the Constitution. And probably the most controversial example, Professor Roeder mentioned, would be campaign finance law. He was strongly against really much campaign finance law at all, and he applied it not just to individuals but to corporations. And that's already been a huge factor in the campaign with Bernie Sanders, of course, and others. Donald Trump brings it up quite a bit too. With respect to religion, I think he actually comes out the other way. He saw more of a place for religion in the public sphere than many of his colleagues. And as was mentioned, he also allowed for more burdening of religious practices and the free exercise clause. He was strong on free speech, maybe not as strong with respect to equal the Establishment Clause, and there he saw more of a place for religion in the public sphere. And I think that probably is influenced quite a bit by his originalism, that the framers were much more comfortable with religion being in government than we are today. With respect to unenumerated rights, of course, he is famously not very protective of those. He thinks that the judiciary shouldn't have much of a role in protecting unenumerated rights. In fact, he doesn't think that unenumerated rights, for the most part, should exist. And so that would be, of course, abortion, regulations of sexual intimacy, the Lawrence case, the refusal of medical treatment. He doesn't think we should have any right like that. One counterexample, though, that I have a hard time explaining that I've talked about in my scholarship is he is very protective of the rights of corporations not to be hailed into another state to have to defend a case. He does have a strong view of due process rights of corporations and civil procedure. And where I'm thinking right now is the Jay McIntyre case decided in 2013, where he says that New Jersey cannot exercise jurisdiction over a foreign corporation because even though the corporation caused personal injury in the state. He also wants to defer to the states on voting rights. I guess that's a sort of, it's not in the Bill of Rights, but of course that's in the Constitution. We're a democracy. But he wants to defer to the states in voting rights in a way that his colleagues would disagree. Voting ID laws, he in 2008 really rejected any sorts of challenges to those. Partisan gerrymandering, racial gerrymandering, he doesn't want to limit what the states can do there. And the Voting Rights Act, as Professor Roeder mentioned, he also was instrumental in striking down that, which allowed for the states to have more leeway in creating voting laws. With respect to equal protection, he was a champion of having strict scrutiny for any classifications based on race. He was a champion of the blind constitution, the race-blind constitution, and that applied to affirmative action. So he was definitely not in favor of affirmative action. With respect to the LGBT community, though, as we've heard, he has the opposite view. He thinks the states should be able to do whatever they want. And again, that goes back to his originalism perspective that has been brought out. And so I think that's really his legacy in constitutional law. It's a little bit more complicated. It's complicated, it's hard to put an exact label on it, but I think overall what Professor Priester and some others have mentioned is true. With enumerated rights, he's very protective. With unenumerated rights, he wants to leave it up to the states. But some huge things that jump out at me, of course, are the campaign finance issue and the voting issues. So those, I think, are huge issues, and they should be huge issues in the campaign, and I think they will be. And so as the election approaches, I'm excited that these are going to be hot-button issues for the public and not just me and the people in my classroom. Thanks. I think we're going to take questions from the audience if anyone has questions for the panels.
Well, if you don't have anything to say, I can talk.
That sounds like a professor.
One thing I was going to say, though, is tying a lot of this together, is I think one of the things that animates Justice Scalia's philosophy a lot, it comes from sort of the period in which he went through his legal education and grew up as a lawyer, which is the concern about the counter-majoritarian difficulty, judicial activism, court overreaching. And what's interesting is I think we can have, whether you like the term living constitution or not, I think you can have a really interesting, ultimately theoretical, conceptual discussion of who are you more afraid of, the majority or judges? Right? Who do you think is going to lead to more injustice in our society? Decisions made by political majorities and legislatures, or decisions made by unelected judges? And depending on where you sit in society, you're going to often have a different answer to that. People who are in the majority typically like the majority's decisions and don't want judges stopping them. People who find themselves being oppressed or otherwise, victims of policies enacted by majorities that they don't like would prefer the judges step in. And so, and then there's obviously no right answer to that question in terms of, and then really I think what we want in our society probably is a balance. There's some things in which it's appropriate to let the majority decide. There are other issues in which maybe being counter-majoritarian is actually more just. But Justice Scalia was a very, very, very strong believer in majority rule with only very limited exceptions the Constitution specifically enumerates. And he says you want to change that, there's a way to change it. It's called Article 5, right? Not called 5 votes in the Supreme Court. And of course there's a lot of people in society and lawyers and law professors and commentators who take the other view and say, no, it's not that simple. And it is appropriate for the court to step in and stop the majority from doing things sometimes. And Brennan, I suppose, would probably make it a classic example of that. So,
but of course, he also wasn't completely consistent, right? So it's hard to explain Gonzalez v. White, or Raich, the medical marijuana case, where he jumps sides and says the state of California can't legalize medical marijuana, right? Or, again, with the Second Amendment is maybe in the Constitution, but it had been interpreted not to give an individual right for pretty much our whole constitutional history. And it never, right, the founders never would have thought it applied to the states because it's in the Second Amendment, it's not in the 14th Amendment, and it hadn't been applied to the states for our first 200 plus years. But yet, he wants to tell the states, no, right, states can't regulate guns. Right? And so, yeah, there's maybe a hook into a textual element there. And even in his concurrence, he's a little, well, I'm going to go along with this because I think it's kind of the way we've done it with other unenumerated rights or quasi-enumerated rights. But again, there was nothing compelling him, right, to take away the rights of states to regulate guns or medical marijuana for that matter. I just think he probably doesn't like drugs, and he likes guns. He's conservative.
Can I jump in on that?
I'm going to jump in.
He likes guns and drugs. No,
That's why there's no autopsy.
so following that's a whole nother situation. Now, following up on Professor Priester's comment about him being a majoritarian, I mean, I think the point, and I agree wholeheartedly, but I think the point probably would be put a slightly different way from him, right? He believes in the system that was set up by the founders, and in democracy. And he's often quoted, saying things like, "How are we, as like 9 judges, any more qualified than Joe Sixpack, out there in the crowd to say, some of these things? There's no special training that God has given them as judges to somehow be able to decide what all of your rights should be." So, it's not that, he likes to squish the little guy. He looks at the system and says, "Look, I'm a champion of democracy. The Constitution was meant to do certain things, and it wasn't meant to be a grab bag of enforcing every policy that we might happen to like as judges. That's why we live in a democracy, and there's a process for all of that." So I think he was a huge believer in that. But addressing Professor Roeder's point, he also was a huge believer in the Constitution. And if the Constitution says you can't do something, then yeah, he's going to say, or if it says this is Congress's job, if it says, hey, Congress can regulate commerce, and then he's going to be saying, all right, well, the Constitution says Congress can do this, so yes, the state, sorry, you lose on that marijuana issue. But anyway, that's all I wanted to add on.
Tony, can I?
Yeah, you jump in after that.
I mean, I agree with everything that's been said, and you all heard me say how much I admired his commitment to rational discourse. I wish every member of Congress were a Scalia. I would be fine with, in fact, his politics, because I know that it would be a fair fight. And I think Congress we're not seeing fair fights at all. We're seeing dysfunction. He famously said in an opinion called On Kale that a gay man who was harassed for being effeminate on an oil rig by a bunch of macho guys could sue under Title VII because he was being harassed because of sex. And that derived directly from a very clear rational argument that because of sex is what is protected, and the masculine men making fun of and harassing and bullying an effeminate man is clearly because of notions of what sex should be. He also agreed with protecting the burning of the American flag as a matter of free expression, which one would not necessarily think would be his thing. On the other hand, and this is not constitutional, but in the area of judicial ethics, he was the strongest opponent of the model rules being applied to the Supreme Court. You may or may not know that those are the only 9 judges in the country to whom the model rules and the model judicial code do not apply. And he said, we're educated, smart enough, and if we got here, we should be trusted to have the discretion and the judgment to do so. So I think that smacks, to me, something of elitism and maybe his inconsistency. But again, bottom line, I think his commitment to reasoned discourse is still what trumps everything else.
So I would agree with what Professor Kolank said about how Justice Scalia describes himself and describes his opinions. I would agree, though, with Justice. Not yet.
That could be number 5.
That's a lot of clerks, right?
Right. His decisions did not always reflect that. And I didn't want to have a negative presentation, but I think it was, it's hard for me to say that the Constitution supports, the letter of the Constitution or the history of the Constitution supports what he's done with the Second Amendment, supports what he's done with voting, supports what he's done with free speech, in a number of areas. I think that's true, and I think that gets back to my original point. Who is on the court matters an awful lot. As much as anyone wants to say that they're just neutrally interpreting the Constitution, they're calling balls and strikes, that's not true. I mean, that's a bunch of malarkey, right? As Joe Biden would say, that's not true. The Constitution is a very, I always had the pocket Constitution with me. I don't have it right now for some reason, but it's a very short document. Doesn't say a whole lot. History is very subject to interpretation. Historians usually don't like a lot of Justice Scalia's decisions from a historical perspective, and there's just not always a clear answer to this. Even if you're an originalist, you can reach different results in a lot of these cases, and not everyone is an originalist. So, I mean, I think that just gets back to my point. Who is on the court matters an awful lot, and we need to decide, do we want someone who reaches those results or not?
But I also think it's a great point just to remind, all great men and women are fallible, right? And so the fact that he sometimes didn't live up to his own standards doesn't mean that the standards are fake or that he didn't mean them. But at the same time, yeah, I mean, and actually in the area I write about a lot, in the Sixth Amendment jury trial and sentencing, there's several cases, including one from 2 years ago, where the two opinions, the majority of the dissent, are by Thomas and Scalia, arguing about what the history says, right? And Thomas says, so the history says this thing, I'm an originalist too, right? And the history says da-da-da-da-da, and Scalia says, no, you're reading the cases wrong, the history says this. Right? And so you guys are two biggest originalists, and they're disagreeing on what the history is. And of course, they vote together a lot of the time because they agree on what the history is most of the time. But of course, people who believe in the living Constitution often disagree on what the living Constitution means too. So, and I think that, to me, is ultimately the key point in all of this, right? The idea, and to me, this is the biggest critique of any theory of judicial restraint, right? Which is the idea of judicial restraint. It's a goal, it can be a goal, but the idea that we can have a rule to enforce it is a myth. All judging is an exercise of judgment, especially at the level of the Supreme Court. All judging is about judgment. So what we should be seeking in Supreme Court appointments is people with good judgment. And then just hope that they don't overreach once they have the power. But the idea that the law is objective and constrains judges, I think, is
I want to add one piece, and I know we're getting close to 1 o'clock. Looking at who he was, and starting in some ways with Professor Kohl's observation that he was a devout Catholic, very committed to family and children, as we can see from his life. And thinking about the two cases that I've been writing about, I wanted to have a conversation with him. I wanted to have a conversation with him about this most recent case and why he came out the way that he did. And one of the possibilities is his personal commitment to the traditional family, to marriage that the Native American dad, in this case, wanted to get married. That so in Justice Scalia's eyes, he was trying to do the right thing in what he thought was right, not just legal. And so I think there is maybe not just human beings are flawed, but human beings, including justices this great, are influenced by their own beliefs. And it might not show up in the opinion where he's coming from, but I think there's got to be some personal views going on as he reaches the conclusions that he comes to. And for me, in these two particular cases that are very, very, seem very, very different in terms of his view. that I think might tie to his Catholic faith.
And that may not even be conscious, right? It could be subconscious. I wasn't trying to say that he was intentionally trying to foist his politics on the nation, but I think it matters, right? I mean, if his personal inclinations were different, he probably would have reached some different results in some of these cases. But that's not to say that he's up there lying or anything like that. I mean, I think the same goes with every justice on the court.
I'll say, interestingly, I think his family relationships may also explain his concurrence in Troxel, where he says parents, there is no parental right. It's a fundamental right. It's a Ninth Amendment, unenumerated right that has dubious pedigree in some of those Lochner-era cases. And Troxel is the grandparent case, right? And Scalia is probably much more of a grandparent now with his 30-some-odd
30-some
grandkids
kids,
than he is a parent, right? So what you would think is a very conservative parental rights case where the majority is saying parental rights, right? And parents should have the primary say in this investments with the child. He's like, I'm not sure about that. That parental rights stuff, that's made up. That's not an enumerated right. That's part of the privacy rights, right? So I mean, in that case, he's kind of siding with the grandparent because guess what? He's now a grandparent, and maybe some of those grandkids don't really know.
He can't possibly be deciding a case like that. You gotta be saying this tongue in cheek.
But Chris
But it's
also,
mysterious why he wouldn't think that parenting.
Isn't that
but
the case?
Chris, that also, I think he really sticks to his state's rights idea that this should be determined on a state-by-state basis. Not so much I agree with the grandparents, but the Washington Supreme Court deemed this statute unconstitutional. Send it back to Washington to deal with the state's rights issue.
Can I say, just as perhaps a broader comment, it seems to me that we have, we will not have a voice that is, I guess in many ways, this kind of powerful paradox again. I don't know that there will be an originalist voice like this ever again, because of the way society and the world are changing. I don't think even the most conservative members of the court who are younger now really believe some of the ideals that Justice Scalia really stuck to with consistency. And so I think the great irony is that this person who believed that the judge should be a neutral vessel was the most human, flawed, and also wonderful of people. You knew a lot of things about him. He could not keep his mouth shut off the bench. You know, he did this. My wife's an Italian American, and she said, I cannot believe the Supreme Court Justice did that to a group of people who were asking about Bush v. Gore, and we said, get over it. He did a lot of things that judges may not be becoming of the highest judges in the land, including saying ethics rules don't apply to us. But that being said, when he was writing, when he was debating, he really was the embodiment of a traditional originalist justice, and to have that kind of brilliance brought to that position, I say, Tony, I feel for you because I don't think that you really lost a big one there.
All right, well, thank you. It's 1 o'clock.